Okay, we're going to get started so we can make sure we don't go over time. I just want to welcome everybody to CIT's Legislative Review. Thanks for spending your lunch hour with us. We have just a few housekeeping things before we get started. This webinar does qualify for an hour of CLE credit. So if you are an attorney, if you want to put your name and your bar number in the chat, and the activity number will be given to you at the end. As in years before, we're going to be sharing our spreadsheet. This spreadsheet was done by Teresa and I. So this basically is our 2 cents on the bill, no one else's. So if there's any mistakes out there, blame us, not my fabulous presenters. This webinar is recorded and it will be out on our YouTube channel as soon as Tracy can make that happen. As you can see of our list of presenters, we have a wide range of experience and talent out there. So I feel very blessed that we have such a wonderful panel out here. So we're going to go on to the next slide, Tracy. So what is CIP? We are a federally funded department under the Nebraska Administrative Office of Courts and Probation. We basically facilitate multidisciplinary teams that are judge-led across the state, known as Through the Eyes of the Child teams. These teams collaborate with local people in their community, anybody from teachers, social workers, probation, health and human services, local attorneys, just to improve issues in juvenile court. Each team selects their own projects and goals. They are led by project chairs, Judge Heidemann and Judge Rowland, since the retirement of Judge Kindler, who we miss dearly. We do data collection and reporting. They develop resources for local teams, and the judges work on a statewide basis to address concerns in the juvenile court system. The Through the Eyes of the Child initiative, obviously through CIP, we hold several events. We have regional conferences, lecture series, webinars such as this one, plus trainings that are open to public, court staff, and any sort of stakeholders in the juvenile field. And we also have our Children's Summit that comes every 3 years. This is the 3rd year. So mark your calendars for September 13th and 14th out in Kearney this year. Usually at our legislative review, we do just kind of a little short, how does a bill become a law? And since we are a unicameral, I can't just go to Schoolhouse Rock and play it for you. So the bills are introduced in the first 10 days of a session. The bills all get a fiscal note to estimate what the cost to the state, county, or city can be. Each bill is in reference to a committee, and every bill gets a public hearing where individuals can testify in a neutral capacity for or against the bill. After the hearing, the committee votes to either send the bill to general file with or without amendments. They can take no action on a bill, or they can indefinitely postpone it. The next step is, if a bill goes forward, is general file. And that's the first time the full legislature gets to debate and vote on a bill and maybe add any amendment. It takes 25 votes to adopt amendments and then move the bill on from general file. If you see something that goes to enrollment and review, this is when they incorporate all the amendments and they also check for grammar. The next stage is the select file. This is the second round of debating and voting, and it's another opportunity for amendments. Then it goes to E&R again. And then if it gets to final reading, the bill is read aloud by the clerk unless it's waived by a vote of 30 senators. At this point, it cannot be amended at final reading. However, it could be sent back to select file if for some reason they want an amendment. It does need a majority vote to move on for signing. Once it goes to the governor, he or she has 5 days, excluding Sundays, to decide on what to do with a bill. The governor can sign, line item veto, or just veto the bill. In order to overcome a veto, it needs to have 30 votes. So after 3 months, after adjournment is when most bills become law unless there is an E-clause. Some bills you'll see have a priority designation. Each senator gets one, and each committee gets two, and the speaker gets 25. And that deadline is coming up soon. I believe it's February 22nd. We are in the short session of the legislature now, and the projected end date is April 20th. And that being said, I'm going to turn it over to Teresa to get started.
Before I introduce our first presenter, I thought of one more housekeeping item. If you have questions, you can go ahead and put it in the chat. We'll be monitoring it, and then hopefully we'll get to them at the end of the presentation. So starting us off today, we have Sarah Helby. She's a staff attorney and director of the Child Welfare Program with Nebraska Appleseed. Welcome, Sarah.
Thank you. Okay, I'll jump right into it because I know we have a lot of presenters, but I just want to start by thanking CIP for the opportunity to present today. I just want to mention a few bills that are priorities for Nebraska Appleseed this session. And the first one is LB 932, and that was introduced by Senator Megan Hunt of Omaha, and it concerns the issue of Social Security benefits for state wards. So this issue was brought to many people's attention by a 2021 investigation by NPR and the Marshall Project, which found that a number of states, including Nebraska, receive foster youth Social Security benefits on their behalf and then use them to pay for the youth's care without telling the young person, their family or attorneys. And in Nebraska, in fiscal year 20, just to give you kind of an idea of the amount, the state received $2.6 million of Social Security benefits on behalf of Nebraska's foster youth. And as just like kind of a little reminder of Social Security, many youth in foster care qualify to receive Social Security benefits that could be either based on their parents qualifying for old age, survivor, or disability benefits. So like if a parent of a child has passed away, or because the youth themselves qualify, and that would be in cases where the child has a disability, including a mental health. And we know that a number of kids in care face both physical and mental health disabilities. These payments are about typically more than about $700 a month, and they're meant to provide monthly financial support to replace income that they would otherwise be able to receive in the case of a parent, or to provide for extra financial support because of their circumstances. But again, Nebraska contracts with a private company that helps apply for those benefits and then reimburse the state for the cost of care, even though there are separate state and federal funding appropriated for foster care. So the bill 932, introduced by Senator Hunt, would provide certain protections for youth who receive Social Security benefits while in care. First, it would require HHS to screen all children for potential eligibility for SSI within 60 days of entering care, to apply on their behalf and to appeal any denials. It also it permits then the department to apply to be and to accept appointments as a child's representative payee. That's how they're doing it when they intercept those benefits. It's because the children are state wards, the department, and it's permissible, it applies to be the child's representative payee. So the bill will still permit that, but it then requires HHS to use or conserve the benefits for the child's best interest. That's consistent with federal law, including the child's reasonably foreseeable future needs, and then to hold those benefits separate and apart from department funds and special interest-bearing accounts. It would also require HHS to notify the child in a developmentally appropriate manner and the child's guardian ad litem of the application for benefits, any requests for the department to be the representative payee, and to provide an accounting of benefits received. And then it provides for certain savings of those benefits for young people. So current state statute allows the state to save, allows the youth to have access to $1,000 before the department can start to spend those benefits. The bill would increase that statutory savings limit to $2,000 for all youth, and then require certain savings of a certain percentage of benefits for youth over age 14. So require the state to save 40% of funds starting at age 14, 80% at age 16, and 100% at age 18. And then finally, the bill would permit children or any party to a juvenile proceeding to request access to the child's funds for the child's personal use. And it would require DHHS to permit that access if it was found to be in the child's best interest, and then also provides that any denials of those requests can be appealed under the Administrative Procedures Act. So that's kind of a lot, but we know that youth leaving care are at risk for a number of harmful outcomes, including high rates of homelessness. This bill would permit some asset building for young people as they age out of care. It was modeled after other state statutes, which have similar protections, and is most closely tracks a statute in Maryland. And LB 932 had a hearing in front of the HHS committee on January 28th, and we're continuing to monitor it. The next bill I wanted to mention is LB, and I think in other presentations we've dropped that NPR Marshall Project investigation story into the chat, and I can do that later if you haven't had a chance to read that. It is a really interesting article on this issue. Anyway, but moving on, LB 1000 is the next bill that I wanted to mention. It was introduced by Senator Ben Hansen. This is a bill that we've been working on. Appleseed has been working on with some local partners and a national group called Let Grow, which is a free-range parent group. My husband thinks that's funny because I tend to be actually personally a helicopter parent. But the national group is sort of interested in not criminalizing reasonable independent childhood activities. So that is kind of the intention. The bill would also update Nebraska's definition of neglect, which is pretty broad. Similar bills have passed in 3 other states, Utah, Oklahoma, and Texas, that again protect the ability of children to engage in reasonable childhood independent activities without parents being called into the hotline or brought into the child welfare system. So those types of activities are things like walking to school or playing outdoors, remaining unattended in a vehicle when it's not too hot or too cold, remaining unattended at home for a reasonable amount of time with provisions for reasonably foreseeable emergencies that may arise, that those types of things do not constitute child abuse or neglect in and of themselves for children who have sufficient maturity, physical and mental abilities to avoid substantial risk of harm. We think this adds to the ability of child protection to screen out cases where there is not evidence of neglect and help conserve resources for more pressing types of cases. What I think is really compelling is that we know in Nebraska, only 5% of total reports to the hotline are substantiated. And of those 80%, so 80% of the 5% involve physical neglect, which is often an economic issue for families. We also know there's a significant disproportionality of children for children and families of color, particularly at the front end of the system. So just to get a little more specific for those lawyers and others, the bill would amend 43-247-3A to narrow the language around lacking proper parental care for parents who willfully refuse to provide such care despite being able to do so, and requiring that the parent refuses to provide the minimum necessary care for the health, safety, and well-being of the juvenile, rather than some broad words like proper parental care. So it's updating some of the language. The bill also amends the parallel termination and criminal neglect statutes. So I think that kind of covers most of it. The bill also, there's a provision of the criminal neglect statute that currently reads knowingly permitting a child to be placed in a situation that endangers their mental health. It also the bill would clarify that that's only under circumstances such that the danger is sufficiently obvious that a reasonable person would not cause their child to be placed in such situation. So that's a particular piece of our statute that I think is broad, and trying to narrow that a little bit more to I think what most of us think as criminal neglect. The bill was actually referenced to the Judiciary Committee. We were thinking it would probably go to Health and Human Services, but it was referenced to the Judiciary Committee, and it's scheduled for a late hearing on on March 3rd, which is actually the last day of committee hearing. So that one has not had a hearing yet. And then the last bill I wanted to mention is LB 1113 that was introduced by Senator Terrell McKinney, and it would direct federal COVID relief or ARPA funds to create a 2-year pilot program to provide monthly guaranteed income of $1,000 per month to young people after they exit the B2I program to age 21. This bill was modeled after a successful programs in several other states, particularly California. So the specifics, any young person who exits the Bridge to Independence program at age 21 within the 2-year period from January 1st, 2023 to December 31st, 2024 is eligible to receive the monthly support through December 31st, 2026. And the reason that those dates were selected is because there are certain requirements for the for dates by which the federal ARPA funds must be designated and spent. There are no other requirements of the program. It's truly unconditional support, and there is significant. So as compared to the Bridge to Independence program, where there's monthly caseworker visits and education and work requirements. This is truly unconditional support. There's significant research to support the impact that these types of programs can have in terms of improving income, or improving outcomes for this population, and hopefully income too, including research through the University of Chicago's Chapin Hall Center. The bill also, to that end, requires an independent evaluation of the pilot by a research institution. And I would note that even though the program doesn't specifically include case management like the B2I program, all young people in the program would be eligible to receive supports through the Connected Youth Initiative, including coaching and other services. So it would really dovetail nicely with existing programming, and we think puts Nebraska in a good position for a program like this with the infrastructure already in place to help young people transition successfully and avoid that cliff effect that we see. This bill had a hearing last week on Wednesday in front of the HHS committee, and we are continuing to monitor this one as well. And with that, I don't know if there's any questions, but that concludes the bills that I wanted to cover. So if there aren't any questions or we're going to keep powering through, I will hand it off to the next presenter.
Thanks so much, Sarah. We have next up Dennis Marks. He is the Deputy Public Defender in Circle County.
Well, thank you. Can you hear me okay? Because okay. Just want to make sure I'm unmuted.
We're good.
Okay. Well, nice job, Sarah. I'm not going to be as thorough as you. I'm going to more or less riff on the 4 bills that I'm going to be discussing today. And if there's any questions, I don't know that we'll have time for that, but you can certainly call me or email me at some point. One of the first bills I wanted to talk about was LB 732, which prohibits the use of deception with juveniles. And that prohibition applies when law enforcement is questioning, interviewing, or interrogating a juvenile involving a criminal act. And they've done a nice job of kind of describing or defining deception as lying about evidence in a case is one example or one definition. And what they mean by that is when law enforcement tells a juvenile, hey, your fingerprints were found on the weapon, so you might as well tell us what happened, when in fact no fingerprints were actually found, or any kind of check on fingerprints. The second example is when law enforcement represents or communicates facts or information concerning one of 3 situations: leniency in an arrest. So that kind of applies when law enforcement tells the juvenile, tell us the truth, and we, law enforcement, will go easier on you. It also applies when there's a representation concerning leniency in prosecution. So when law enforcement says, hey, tell us the truth, and I'm sure the prosecutor will go easier on you. And the last situation covered by the statute is leniency and disposition, and it's basically tell us the truth and the judge will go easier on you. And that's all in exchange for information or admissions. The statements that the statute refers to can be, it can be verbal or it can be written. And if you obtain a statement through deception, then that statement is inadmissible against that juvenile in any juvenile court proceeding. I will say that one thing I didn't really see in there that might be omitted was when law enforcement tells a juvenile, hey, tell us the truth and you won't have to stay in detention, when in reality that is not the fact. But I think this statute can cover that situation as well. I like this bill. Law enforcement, I'm a process guy, not so much a result guy. I think law enforcement uses the same training and techniques on juveniles as they do adults. And in this situation, they're using, a juvenile's lack of experience, their naivete against them. When you think about the purpose of questioning or interrogating youth, it's more than just obtaining information. It's usually obtaining information with the purpose of having that juvenile implicate themselves. It's for the purpose of not just for the purpose of solving crimes, but making trials go easier. But the downside of that, and it's a huge downside, is the use of deception can result in false confessions by juveniles. And really not just juveniles, it can occur with adults, and I don't think you have to look any further than Beatrice to see how that works. When you think about the use of deception in juvenile court, I always like to look through the lens of adolescent development. And youth have a really strong sense of fairness and equity in their teens. So when you have law enforcement lying to them, it really violates their sense of trust. And then they have a difficult time trusting authority figures, and their view of the court system oftentimes for an extended period of time is not very good. So hopefully there's some movement on this bill. The second bill that I wanted to talk about was LB 792, and this is the bill where the legislature is looking to appropriate $15 million to Health and Human Services for renovations out at the YRTC Kearney. And I just really wanted to throw this one in there as kind of more or less as a shout out for some much needed reservations. It really gives the boys out at the YRTC a movement from a dorm room like setting that they have right now to more of an individualized private setting. And so what the money's going to do is it's going to go to building 2 new housing units for 24 to 48 youth. They're going to design and renovate a treatment and programming center. And then there's some items that they're going to replace as well. I like this bill because, number one, I think it's overdue. It's going to increase safety on the campus, and it's going to come in line with best practices, because best practices call for individual rooms rather than these dorm-like settings. The third bill was LB 879, and this is the no contest plea and delinquency proceedings. Apparently some counties are taking no contest pleas in the delinquency side of juvenile court, which I was not aware of. I think what this bill is trying to do is make the no contest plea uniformly available, because when you look at the statutes, it's really only available in child welfare cases on the 3A side. Believe it or not, I am not a proponent of this bill. And I've talked to several other attorneys who represent juvenile and delinquency cases, and they're not proponents either. And the rationale is that I think it's confusing and counterproductive. When a juvenile accepts responsibility, or at least admits to their behaviors, that is pretty much a cornerstone of juvenile court, and things move from that. You move to disposition, you move to services, you move to supervision, you move to case management. A no contest plea is a kid saying, I'm not saying I did, but I'm not exactly saying I didn't either. And I don't think there's really any place for that in the delinquency side of juvenile court. They're not adults, you know, they're not in the same developmental stage, and the purposes for that particular plea is not the same. You know, I think you either admit or you deny. And if you deny, then ultimately you can adjudicate. But I just think it's harder to get buy-in for rehabilitation programming and interventions if a juvenile is not admitting to the responsibility for their behaviors. We don't do Alford pleas in juvenile court. We shouldn't be doing no contest pleas. And an Alford plea, for those who may not be aware, is basically a best interest plea. You have those in adult court. Probably have them on the 3A side too, but it's just not a place that's appropriate in juvenile court. And the last bill that I was going to chat about was LB 883. And it covers a few different areas, but I'm going to kind of focus on two today. One is the developmentally appropriate Miranda language, and the other is requiring a parent or guardians present when requested. I think the use of developmentally appropriate language when explaining Miranda rights by law enforcement to juveniles, it's long overdue. Sarah Helvey talked previously on her bills about how other states are moving in some of the areas that we're in. There have been movement in other states on this particular subject as well. I wouldn't call it a nationwide movement like the elimination of shackling was a few years ago, but it is starting to get some traction nationwide. And I'm just going to read you what the developmental language is law enforcement has to explain to a juvenile who's in custody, and in custody basically means that you don't have the right to leave. You have to be there when law enforcement talks to you. You can't walk out that door, or turn around and walk away. So law enforcement will explain to the juvenile that you have the right to remain silent, which means you do not have to say anything to me unless you want to. It is your choice. If you choose to talk to me, whatever you tell me, I can tell a judge in court. You have the right to have your parent or guardian with you while you talk to me. You have a right to have a lawyer with you while you talk to me. You may have the right to get a lawyer for free. If you get a lawyer, he or she can help you if you decide that you want to talk to me. And these are your rights. You understand what I have told you. And follow-up is, do you want to talk to me? So I really like the use of that developmental language. There are studies out there that show that any kind of Miranda warning above the 6th grade level may not be understood by a majority or a substantial number of our juveniles. And for you defense attorneys out there, when you're interpreting custody with youth, just a reminder, you know, there's that JDB versus North Carolina lens that we use. It's the United States Supreme Court case that talks about custody and juveniles. So we always want to view custody and Miranda through the lens of JDB. Right now, the current language that law enforcement uses when explaining Miranda, it's easier just to allege that a client just didn't understand the Miranda warnings and it wasn't a knowing, intelligent, or voluntary waiver And we can get experts like a forensic psychologist or a speech language pathologist to kind of show that lack of understanding. And again, there's research studies out there. I think Thomas Grisso and Lawrence Steinberg, I've got several articles with them on that show the lack of understanding to Miranda warnings when they're not explained in a developmentally appropriate way. And I'm also aware that there are organizations that recommend the use of developmentally appropriate language. So it isn't just myself or some of my colleagues that think this is good. The International Association of Chiefs of Police and the Center on Wrongful Convictions of Youth also recommend developmentally appropriate language with the explanation of Miranda. So, and again, if you need sources or sites, just contact me and I'll get you that stuff right away. The second part that I wanted to talk about was the presence of parents, and I think that's a little bit more controversial. And what happens is if you've got a juvenile who's being questioned or interviewed or interrogated, and that juvenile requests to speak to a parent or guardian, just like they would their attorney, then this bill says that questioning has to stop immediately. And it doesn't resume until the person that's requested arrives. And when that person arrives, then the juvenile has to see that person without unreasonable delay, and they have to consult with the juvenile and the person or persons. They have to consult in a private place. So hopefully it's not in a place that law enforcement is watching them, that's subject to videotape and audio taping. So hopefully it's in a private place where that's not occurring. Now, there are, like anything else, there's some exceptions to this. And right now there's two exceptions. And one is if that person that they're requesting be present was actually involved in the crime that's related to the juvenile's detention. And I think that makes a lot of sense. And the second exception is the presence of that person or parent who's being requested constitutes a danger to that particular child. And again, I think that makes sense. I think Bree will probably talk about some other situations where that exception could occur. I don't know. We'll see.
That's a good segue because we do have Bree up next.
Yeah.
So thank you so much, Dennis. I will introduce our next presenter. It's Bree McClarty. She is a deputy county attorney in Dodge County. Welcome, Bree.
Yes, hi, thank you. So the first one I'm going to talk about is one that's Dennis talked on first, which is LB 732, the deception by police officers. So obviously from the county attorney's perspective, it's a slightly different interpretation or how we're looking at the bill. The one thing I just kind of wanted to point out, Dennis did a great job of kind of an overview of what the bill does. And so in looking at the language of the bill, the kind of thing that we looked at and saw and kind of looked at through the lenses in that definition of deception, it's pretty broad. I can see from the defense attorney's side how that kind of, those examples are the ones that Dennis thought of, but in kind of looking at the other side of it, it's a pretty broad description of what deception is. And I feel like it doesn't quite address or take into account that there are some specific bills or specific statutes that offer a type of immunity for providing information. So I know, like, if a kid buys a vape or has possession of a vape or some similar type of prohibitive object, there are some specific statutes that grant immunity if that juvenile were to tell law enforcement, like, yes, I got this vape from this person. They get immunity because they then go after the person that sold them the vape. So there's just some interesting conversations that need to happen about this bill and how broad the definition of deception is, while we want to think about this definition exclusively in this context. The statutes are all interrelated. So if someone is looking for a definition of deception and they look at that statute saying, well, this is how it is here, we could apply it in this situation as well. It just kind of creates it's a classic lawyer trope, the slippery slope. And that's kind of where the county attorneys are looking at it, as there are situations where we do ask the kid, like, tell us this and you won't be prosecuted, because that's actually the protection that's in the statute. But by the definition in this law, it would now be deception. So it's an interesting concept. I understand where Senator McKinney's coming from. I think his first definition of lying is pretty accurate. That's a perfect definition of what misrepresenting facts that are in the case or evidence that they have. But that's where the county attorneys, in looking at that bill, was kind of like, oh, whoa, that's interesting. And as someone who has watched a lot of the interviews and videos of kids that are having these conversations, sometimes even with their parents, there's a lot of questions that they have because they're not familiar with the court system, and they're asking the law enforcement officer, like, will they be eligible for diversion? Like, what's going to happen next? They're kind of just freaking out about that they've had this law enforcement contact. And some law enforcement officers, they want to be helpful. They want to say, if this is his first time, it's likely it's going to be diversion. That's how our county attorney handles it. But then they're now making that statement, is that deception? So just with anything in a statute, it can be open to a myriad of interpretations, and it will never be perfectly tailored for any situation. So that's why it's kind of an interesting concept. I know one that was pretty heavily talked about in the committee. And we see it just fact that there are bills like this. Dennis mentioned another one of Senator I think Hansen's bills about the Miranda rights. When we're talking about juveniles in the juvenile court system, they run the gamut from 11 to 18. What's developmentally appropriate for an 11-year-old versus an 18-year-old? So the hard part about juvenile court is it is so flexible and it's so expansive to really help and protect juveniles across the board. But then that also creates so many areas of conflict or misinterpretation, or it's hard to tailor something to meet all the needs without accidentally going down a different path that we didn't want to go down. So that's something with LB 732. So I'm not repeating what Dennis kind of said, is something that we saw as the county attorneys as problematic. But it's an interesting conversation that is happening in the Judiciary Committee about those type of interview practices with juveniles, because the bill is so much more expansive, like Dennis said, than what you see in the typical protections in adult cases where there's an adult interview. And I think a lot of that is trying to be reflective of the developmental needs of juveniles. But now the question is, how much more protection do they get? How much are we going to modify and change law enforcement tactics and interviews? And where's that balance between public safety and why they're trying to get this information and individual rights and freedoms and protections? So it's an ongoing conversation that I think will be happening years, decades, millenniums to come as we work with the juvenile court system. The next one we're going to talk about is LB 879. And this is one of those fun ones where Dennis and I are flipped again. Surprise. So the no contest plea on the juvenile side, it is something that my county does. We do accept no contest pleas on juvenile delinquency cases. And I think a lot of our position for Dennis and I is, where are we coming from? Dennis, as a public defender, is working with those individual juveniles. He's having way more conversations with them than I am. If they're not represented, I'll probably have an initial conversation with them about, hey, here's your first court hearing. Here's what's going to happen. If they ask me for a plea offer, I'll say, this is what my thoughts are. If they ask for an attorney, then I stop talking to them. We get them an attorney, and someone like Dennis is the one that's communicating with them from then on out. So he has a lot more experience with kids in kind of how they get to that thought process of admission versus not. For my side on the prosecutor, I'm looking at, how are we balancing getting services to this kid? I see a kid that has a need, whether it's, a drug-related charge, an assault charge or something, where I want to get services started as soon as possible, because the longer they're lingering without services, the more opportunities or possibility there is that a new law violation will happen, because we're not addressing the behaviors. We can't court order anything until it's adjudication or disposition. So for me, if the kid is not quite ready to say, I did it, I admit, but they're willing to say a no contest, and that gets me to services starting sooner, to me, that's just the start of our journey in their probation case. They're going to get services like aggressive replacement training or decision-making classes with the goal that on the other end of their probation, they'll be able to reflect on, these are the decisions I made that got me to that situation. Here's how I'm going to change those decisions in the future. And my goal is that they take accountability and responsibility for their actions by the time they're done with probation. And that's the purpose, is recognizing that their actions have consequences, how to make better decisions in the future. So for me, having that right at the very beginning, not a deal breaker. I want those services to start sooner and that case to progress. So that's kind of the prosecutor side of why we're open to no contest pleas on the juvenile delinquency side, because the goal is for them to take accountability throughout the course of the case. So that's just LB 879. And then LB 1010, I wanted to give a little more background because I realized that not many people are actually familiar with the program that's called CJIS. It's Nebraska Criminal Justice Information Systems. It's something that's accessible by county attorneys, law enforcement officers, probation, and really is a database of everything in the court system. So for example, every county attorney has access to it. In my office, we actually, our access is tailored based on what we do. So as a juvenile county attorney, I have access to all of the child abuse and neglect intakes that come in. I have access to prior juvenile court records or court cases for, juvenile delinquency cases, but also juvenile dependency cases where the parents may have had 3A cases open before. It's like any government website, it's usable, but it's not user-friendly. So the bill that Senator Geist is talking about in LB 1010 is, this access to law enforcement officers about, who's on probation, who their probation officer is, and what their orders are. It's available, but this is like an 18-step process to find. And what she was talking about is when law enforcement shows up to, we'll say, an incident in a domestic incident in the home, the person can look up the officer can look up the name of the individual there. It's going to take a while to figure out, do they have a no contact order for the person that lives at this house? Do they have a, search and seizure clause? Are there concerns about that their probation is for a weapons charge? Some of the stuff is harder to find at the ready, and it's something that law enforcement wants before they walk into that situation or as they're addressing that situation to know kind of what's available and what is the real issue here. And so that's what part of LB 1010 is about, is making that information more readily accessible to law enforcement officers to utilize when they're out in the field. The second part is specifically GPS coordinates for juveniles that have an ankle monitor on. So typically an ankle monitor is put on a juvenile when there is a detention hearing. It can be a term of probation. If there is one put on in an emergency situation, we have to have a court hearing within 24 hours. So whenever there's an EM on a kid, there's maybe 24-hour period max where that was on without due process, where they didn't have the opportunity to be heard in court or to be represented by attorney to fight that EM being placed on. And the process right now for getting those coordinates, even where it's court ordered as a part of probation, it's not a subpoena. It's not a warrant where, an affidavit's done by a law enforcement officer, it goes to the judge, he signs it, and now it's valid. It is actually a motion that has to be filed by the county attorney on the case, asking for that to be released. We have to have a court hearing. The judge hears the evidence, he orders that, then the order is then given to probation and through the AG, through the Attorney General's office, say, okay, you can now release this information. And it can take a little bit of time. In best case scenario, it's maybe a day or two. I'm sure in Douglas and Lancaster and Sarpy, where they have on-call judges, it's probably a lot quicker. In counties like mine, that would probably be about a 3 to 4 day process. I had one situation where it luckily wasn't time sensitive. It was about some kids had been out driving the country. There was a gun involved. They threw it out the window. It took about a month to go through that whole process. But where we kind of see this as an issue is when we have a juvenile that's on the run, that has ran away from their placement, who is in danger, and they have an EM on. Now we're talking about vital time that's lost in those crucial first few hours where the kid has run or is missing. So that's kind of where Senator Geist is looking at. I know in hearing the committee hearing, I think there was conversations about opening it for those type of emergency situations. I think it's an ongoing conversation that we'll be having, because there are times when getting those GPS coordinates for safety reasons would be really important. A lot of testifiers that were opposed to it to talk about the due process side of it. So I think there's room to negotiate and really look at how can we balance having this information ready available, looking for the best interest and safety of the juveniles while also respecting and being aware of their individual rights. So that's kind of what that bill is about. But I wanted to provide some background about what CJIS actually is, because it is limited who can use it, and kind of why they're looking for that information to be more readily available. But that's LB 1010, and those are the only three I was going to present on because I know we're getting close to the end. So
Thanks, Bree. We are running a little behind schedule, but we will keep recording this webinar. So folks who perhaps have to log off at 1 o'clock, you can go on our YouTube channel and watch the rest of it. But our next presenter is from the Separate Juvenile Court of Douglas County, Judge Stevens.
Well, I will be brief, so maybe that will help. In regard to LB 879, I've taken a look at this a bit from a judge's perspective, and this has been an ongoing issue when I was a practicing attorney. The question of a no contest plea being available for juveniles has been on the table for a long, long time. And through the years, this is my personal position based on my different areas of experience, which was as a prosecutor, as a defense attorney, and now as a judge. There are a couple of things that don't often enter into the discussion. But just briefly looking back at the legislative history, I think was in mind when the legislature drafted this legislation. We want to, I think that when it comes to juvenile delinquency matters, we want to hold on to keeping those matters civil in nature and holding on to that as much as possible. When the appeals courts decided that due process required the rules of evidence to be applied in delinquency cases and trials, I think even there they started with due process and looking at those circumstances related to delinquency trials, an application of the criminal rules of evidence to still be approached from a civil nature rather than a criminal nature. And I think it was the legislator's intention, and pretty much it's the nation's intention, to hold on to that perspective tightly and not have the nature of delinquency proceedings be equated to criminal in nature. And I think it has been my thought that applying a no contest plea gets us one step closer in the direction of it being criminal in nature. And also, as Dennis remarked, adolescent brain development, emotional, psychological development, I think heavily influences my perspectives on this issue far more often than not. Professionally, it's been my perspective that if a juvenile can figure out a way to weasel out of responsibility for their actions that brought them before the court, they're going to do that, and they're going to hold on to that through the entirety of the case. So, and a no contest plea allows them to say, I didn't do it, but the evidence would probably show I did. Whereas I have watched youth sitting through a trial who have all the evidence laid out in front of them, and I've watched them surrender to the presentation of the evidence. And even though they're not going to admit anything, you can see in their body language, it's like, okay, yeah, I'm caught. And I think, and so a no contest plea, I think developmentally just isn't optimal. Optimal is admitting or denying or making no response at all and still requiring the state to prove it. The other piece is based on my experience, when we compromise a child's understanding of right, wrong, and integrity in our juvenile court process, that affects their perspective of the whole process. It affects their perspective of the people that they have to work, their attorney, their probation officer, any service providers, the court. And if we try to take a shortcut to hold a juvenile accountable for the circumstances that brought them to court, they see it. And it can have, detrimental is too strong a word, but it can have a negative effect on the successful process and ending of the matter, because they and yet generally they're coming from a place where lack of truthfulness and lack of integrity are involved in the circumstances that brought them to court. So if they encounter those same values in the court, they don't see any distinction between what's going on in court and what they did. And I just think we have to do everything that we can to keep things as clean as we can. And I think a no contest plea just kind of clouds that up. The other legislative bill that I was assigned to speak about is LB 1078. Just quickly, this has been assigned to the Education Committee. And for anybody taking notes, the public hearing is going to be March 1st at 1:30. So this hasn't had public hearing yet. This legislative bill is the unicameral's or senator's efforts to provide the school with power to regulate students' possession of personal electronics in the classroom. And it's based on they're finding that unrestricted use of personal electronic devices during the school day in class interferes with the educational mission of the schools, lowers student performance, and promotes cyberbullying. I have 4 teachers in my family, so I have access to a lot of teachers. And every one of them would say that is absolutely right, as well as used for organizing for fights and figuring out how to skip and lots of other reasons. So when they first saw this, it sounded very attractive. And then lots of questions come up. Things like what happens if the phone, well, no, I'm getting ahead of myself. So what the legislative bill instructs is that upon entering a classroom, the school would have a place that can be seen, a special cubby or a special packaging or something where a student's phone would be placed for the period of the classroom, and the student could retrieve their personal electronic device when class is over. And the legislation also creates some exceptions under the circumstances related to indicating that a student can possess their electronic device if they have some kind of emergency going on in their personal life or in their family, if they have particular health considerations that require them to continue possessing it, like diabetes, like a student who's hard of hearing, like a child who has a heart condition, and there's an app on their phones that helps assist them with monitoring those health conditions. And it has some other provisions that create exceptions that appear to be pretty reasonable. And the proposed legislation also allows the schools to, leaves it within their discretion as to whether or not they want to apply this legislation, which I think is very wise, because one of the other concerns I had was each community is so different and each school district circumstances are so different. To mandate it for everybody may not be the best way to go. But I also thought about things that could come up that could be directly connected to juvenile law. Like, what if a teacher sees something unlawful on a child's phone, and how is that handled? What happens if the phone disappears or gets damaged while it's supposed to be in the custody of the school or in the custody of the teacher? How is that handled? I anticipate right now, at least, especially with the session, how it's going, there will be a lot of discussion about this. I don't know. I have no insight as to how much weight it's going to carry through this session.
Thank you so much, Judge Stevens. Our next presenter is Makisha Judson. She is the Deputy Director of Policy and Legislative Services with the Nebraska Department of Health and Human Services. Welcome, Makisha.
Good afternoon, everyone. I was introduced, Makisha Judson, Deputy Director of Policy and Legislative Services for the division, and I will start off by going over LB 932 by Senator Hunt. And as I believe this bill was reported on a little bit earlier. However, from the department's perspective, unfortunately, we are opposing this bill. This is for state wards and for SSI payments for state wards in youth and foster care who are under the state's care. Right now, through our contract with Maximus, we already do screen youth for SSI payments, as well as what may be contrary to some of the other states is we actually do have individual accounts per child. I believe it was thought that the state of Nebraska puts all of the money into one account for all of the youth, and that's not how we do it here in Nebraska, that each child has its individual account that tracks their funding, and we are audited on that federally every year. And so we have successfully passed an audit in regards to those funds every year, at least since dating back to 2014. We have successfully passed that audit. Now, as a result of this bill, I think one of the major concerns that the department had was also to make sure that the youth services were not interrupted in terms of their economic eligibility for some of their programs. And as it relates to these dollars, they have to be used specifically and allowable expenses. And so there are some regulations on how these dollars are used. They can't just necessarily be used arbitrarily. They have to be certain specific allowable expenses that are approved through the IRS. And so we have talked with folks in Maryland as well as some other states who have provided us feedback in regards to this program. And so we, at this current posture, as it's currently written, we do have opposition to this bill, but we have seen where there are some areas to where we can improve this program to better serve the young people in the state and better provide for them. And so there has been opportunity for growth as a result of this piece of legislation. LB 1000, which changes the definition of neglect, and really, as we have learned with this bill, the overarching goal is to not investigate what would seemingly be poverty per se, and unintentions of the state interfering with the family. And so we have a neutral stance on this bill. There is some language used within this bill that does provide some concern that we would like to get a little bit more specific with, or it provides a little bit of ambiguity, and that is the language of reasonable, in terms of person standard, using the language of reasonable, as well as the specific age of 6 years old being left unattended in a vehicle. And so there's just a little bit of vagueness with some of the language that are of concern, but not enough necessarily to propose any opposition or support testimony. And so we're actually are not taking a position on that bill. I'm going to the floor on that bill. LB 1019, which provides for a pilot program by Senator McKinney, and I believe this is dealing with a juvenile assessment center as well as a family resource center, a 24-hour juvenile assessment center and a family resource center that is housed to do assessments, tutoring, mentoring, and so many other things that some are just out of the scope of DHHS and what we provide. And additionally, the cost of this type of pilot program would be astronomical to man and to staff a program of this sort for 24 hours. In addition to the contracts that would need to be administered with various different community providers and community-based organizations to provide the services that are outlined within the bill. It was a beautiful goal, but the details within the bill, we needed a little bit more information to really outline the bill, the idea and the concept. We support and understanding the needs that the senator wants to do for that area. We support, however, the ability and the capacity for the department to provide a 24-hour facility for not only juvenile assessment, but also a family resource center. And it will require also cross-departmental collaboration to provide some of the services within this bill. And so therefore, we did oppose LB 1019. And those are the three bills that I'm supposed to present on. And that's
Thank you, Makisha. We appreciate hearing the department's perspective. So I'll move on to our next presenter, is Elizabeth Einen-Koperda. She is a managing attorney with Education Rights Council. Thanks, Elizabeth, for joining us. You are muted at the moment.
Better?
Yep.
Hi, thank you. I'm Elizabeth Einen-Koperda. I'm with Education Rights Council, and I was asked to join this conversation to give, I'll call it the education twist on how some of these bills impact juveniles, because a lot of the work that we do is with the education rights of juveniles in the system. This particular piece up here just shows one bill that you've gotten. I had like 5 bills, or are there several that you want me to work through? I'm going to just try and touch on the key education pieces. So the first one is LB 32, which is that deceptive language issue where police involved in deception can have the language excluded. The thing that I would like people to think about in this context is the SRO in the schools as a peace officer. What you have in schools are SROs that wear, quote, an SRO hat, and then they also turn into law enforcement. So they're not law enforcement at a particular point, and then they become law enforcement. In the statutes, many schools are required to, quote, refer a particular alleged offense at the school to law enforcement. So the question becomes, if this bill should pass, all parties are going to want to pay a special attention to interviews or statements procured at or from the school based on the role of the school. What I have experienced often is there will be an SRO in the room while perhaps a principal is interviewing. The SRO maybe even guiding that conversation, and yet then statements are made, they're written, and they are used against a child, because then the SRO becomes law enforcement and takes the statement. So I find that I understand the purposes of this. It is just going to be a challenge, because indeed in schools there is that balance we heard about, safety versus rights, but SROs have definitely been known to tell children things that are untrue in order to get them to make statements, which are then used against them when it is turned over to the juvenile courts, or when they've been referred to the county. So I just wanted to draw the attention to that. With regard to 883, which is the Miranda rights bill, I'll call it, I'm focusing on that Miranda focus. What I would say is, while I fully understand what Dennis has said about this, there is still, again, there's this lack of understanding about what's happening, which is so many of our juveniles are coming to the system from the schools. And what's happening in the schools is when is the SRO law enforcement? In other words, this idea of simple Miranda rights could actually be arising within the school context. But if we haven't really defined when the SRO is acting as law enforcement, it may leave a portion of the population, I'll call it unprotected with regard to the Miranda rights, if that is indeed the idea. There could be a significant loophole. I'm just drawing your attention to this as somebody who works both with law enforcement and the schools. I'm going to jump directly to LB 110 because we've already heard about what's in this bill. The thing I am very concerned about is the insidious aspect to it, where it doesn't distinguish between status offenses and delinquencies. So in my perspective, law enforcement shouldn't be involved in a school-based offense. In other words, a status offense. As the judge said, we don't want to treat anything really from the criminal perspective, and we're already worried about criminalizing status offenses. Often the reason a child isn't going to school may have a reason that is school-based. They didn't provide the appropriate services, so the child is unable to attend based on a disability. So I'm concerned that this doesn't distinguish when we're putting in all this information between status offenses, and I'm not sure whether they would belong there at all. And the other information is I don't know how anything gets off of insidious. Once it is on, I don't think it falls off. So if a judge were, for example, to order a sealing of the records, I am concerned that this part may still be out there. So I would think that there could be a sealing challenge or a challenge in that there could be conflict between those two purposes. So those are my comments on those three. I also was asked to address two other bills very quickly. LB 179. What LB 179 does is it creates two structures within the school. One, educating people about how to stop situations where there could be a danger to harm for an individual or others. But it does permit something called physical intervention to control a student's body. It permits prone restraint. If as somebody engages in it, it alleviates them from responsibility. And it lets kids be removed from school without applying the due process that's in the Code of Conduct. What I am afraid this will mean, should this bill move forward, is people are going to put hands on kids in school. Kids are going to fight back. They're going to be charged with assault. And we're going to see a lot more assaults that started because of a physical intervention that was undertaken. So again, when we're talking about how a child arrives in the juvenile system and rehabilitating that child, this could actually exacerbate the number of children coming into the system, because especially for children who are disabled, if I am approached from behind and I have autism and somebody puts their hands on me, I am going to react in a bad way, but it's my disability that's driving that. And then I'm going to be charged with assault potentially because of that. I have grave concerns about the impact that has on our juvenile system. And I'm going to address one final last bill. I am zipping along because we are behind time. And the last one is the option enrollment bill. It's LB 1211. I think this is actually a really important bill. One of the things that we work with in the juvenile construct is to ensure that everyone understands the rights and obligations of children and how their education is impacting why they're in court and how education supports and services can get them out of the juvenile system faster. What this particular bill does is it allows children with disabilities to get a fresh start in another district. Right now, you may be unaware, but our laws basically say that while there is option enrollment, in other words, I have a choice of where my student can attend school, if I have a disability, that is basically cut off. Any school can say, if you have a disability, we're not going to allow you to participate in option enrollment. Effectively, non-disabled kids may, disabled kids may not. From a juvenile perspective, as I see so many juveniles coming into the system that do have disabilities that have been left unaddressed either by the schools or, they have created a bad situation where the school and the kid no longer trust each other for a variety of reasons, right or wrong. Giving the kid a fresh start is an important part. And this could be a tool for those that are working with children in the juvenile system, so that they understand that there's perhaps one more option now available to them if LB 1211 should pass. I will note that neither 1179 nor 1211 had their hearings. 1211 is up, I believe, on the 22nd of February, and 1179, I believe, is on the 28th. So we'll see how that goes. And of course, I will put my information in the chats if anybody wants to understand more about education rights and how that impacts the juvenile courts and the juvenile system. And that's my presentation. Fast.
Thank you, Elizabeth. We appreciate you zipping along. Our final presenter is Aubrey Mancuso. She is the Executive Director with Voices for Children in Nebraska. Welcome.
Yeah, thanks for having me. And I too will do this quickly since I know we are over time. I would also just add to what Elizabeth just raised up on LB 1010 that we also have a bit of a different perspective on that bill than the county attorneys. In that, as written, there aren't any conditions under which law enforcement would gain access to GPS information. So we definitely have concerns about giving law enforcement access to that information without probable cause. The two bills I will go over quickly are LB 946. This is a bill introduced by Senator Wayne, had a hearing on January 19th, and this bill would prohibit the use of off-label prescription medication for young people in the care of the state. We and many others raised some concerns about this bill. I think the intent that Senator Wayne had was to look at some perceived issues of over-medication for kids in the care of the state, which, I think does raise some important questions. However, it's estimated that about half of medications used for young people are considered off-label because they aren't often studied on young people. And so things like medications for asthma would be prohibited for kids in the care of the state under this bill, as well as many psychotropic medications that aren't necessarily tested on young people. So there was a fairly significant amount of opposition to this at the hearing. I think it's an issue that Senator Wayne continues to want to look at in the future, so just something to watch for, but it doesn't look like it's likely to move forward, at least in this session. The other bill I was just going to mention briefly in this context is LB 1014. And earlier we discussed a little bit about Senator Lowe's bill, LB 792, which allocated $15 million from the general fund for renovations at the YRTC. This is a larger budget bill that covers allocations of the federal dollars that the legislature is looking at. And this would contain an additional $15 million from that pot of federal money going towards those YRTC renovations. And this bill is an Appropriations Committee priority bill, and so is likely to advance in some form. So it is likely that some portion of money for renovating the YRTC facilities that was already discussed will likely be included. And that's all I have to add today.
Thanks, Aubrey. The final source, sort of piece of information is we've included a link to the Legislative Youth Day panel discussion. This is through Nebraska Children and Families Foundation and their Connected Youth Initiative. So some young adults have presented on bills that they have found important. So we apologize that we went over time, but we really appreciate you sticking with us, especially the presenters. Your varying perspectives is what makes this webinar. So we really appreciate your time, and all of these resources will be available on our website and our YouTube page. So thank you all.